Are you an established small business owner or aspiring entrepreneur? Would you like professional advice to help your business grow and succeed? Well, look no further. The Virgin Islands Small Business Development Center is the territory's #1 resource to move your business forward. Enjoy no-cost advising, low-cost training, and technical assistance from experts in both the public and private sectors. The VISBDC is nationally accredited and sustained by the University of the Virgin Islands and the U.S. Small Business Administration. Visit us at our locations on St. Thomas, St. John, or St. Croix, and follow us on social media at VISBDC. For easy access to all our training and networking events, be sure to join our newsletter and download the VISBDC app. The Virgin Islands Small Business Development Center, here to help your business start, grow, and succeed.
Hi, good afternoon, everyone, and welcome to the VISPDC's hosting of the Patent and Trademark Office series. Today's session is entitled Maintaining Your Federal Trademark Registration. This session will discuss required post-registration maintenance filings and optional filings that can help ensure your federal registration protects your trademark for years to come. Allow me to introduce today's lead presenter, Ms. Christina Calloway. Christina Calloway is an attorney for Trademarks Customer Outreach with the United States Patent and Trademark Office, better known as the USPTO. She began her career at the USPTO as a trademark examining attorney, where she served on a team dedicated to reviewing sound and motion trademark applications. Ms. Calloway has collaborated with numerous local and national organizations, educational institutions, and businesses to educate small business owners and creators about intellectual property. Throughout her career, Ms. Calloway has sought to merge her personal passion for the arts and professional pursuits in public service and has been awarded recognition for her service and leadership professionally and personally. She is an executive board member of the Northern Virginia Fine Arts Association and served on the City of Alexandria's Commission for the Arts. A proud Army brat, Ms. Calloway obtained her Juris Doctor degree from Howard University School of Law. She has also received both her Master in Public Administration and Bachelor of Arts in English from Georgia Southern University. Here's a friendly reminder to put your questions in the chat, and they will be addressed by the presenting team either directly in the chat or later during the question and answer segment. A copy of this presentation will be attached to the post-survey event email. So we encourage you after this training to just take a few minutes and fill out the training survey that lets us know how we're doing. So without further ado, Attorney Calloway, the floor is yours.
Thank you. Thank you again for that introduction. And thank you everyone for being here with us as we discuss maintaining your federal trademark registration. Again, I'm just going to reintroduce myself to anyone who has just joined in with us. I'm Christina Calloway. I'm an attorney advisor in our Trademarks Customer Outreach Office of the USPTO. Today, we'll be discussing how to keep your registration alive for years to come. So before we get into that, I just want to go over today's agenda while we're here together. Again, just as a reminder, if you have any questions, please feel free to drop them in the chat. We will answer them there. And also there will be time at the end of today's presentation to ask any questions after we go through the subject matter of today's presentation. All right. So we'll be discussing some trademark basics. I know we discussed last week trademarks and trademark fundamentals and basics. So we'll just briefly cover those and how that relates to what we're going to be discussing today. Then we'll go into what you need to file after you receive that federal trademark registration. We'll talk about some optional post-registration filings as well as post-registration examination, the process that goes through once you file those post-registration documents, as well as some resources with the USPTO that are free and available for you to peruse on our website. So without further ado, let's get started. Just going over briefly our trademark basics and fundamentals. So like we talked about last week, we talked about that trademarks are a type of intellectual property. Intellectual property is something that you're creating with your mind. It's not tangible property, but it is something that can be bought, sold, traded, inherited, and trademarks are a type of intellectual property. Trademarks identify the source of goods and or services. So anything that you are using, whether that's words, terms, phrases, some design elements, color, some stylized font that you're using with those words and terms, anything that you are using to indicate the source of goods and services is a trademark. You may not necessarily say the word trademark. You may say that you have a brand name or you have a logo or slogan that you're using in connection with your business, with the goods that you provide, with the services that you provide, and that is a trademark. A trademark also distinguishes your goods and or services from those of a third party. I always use that example of Coca-Cola and Pepsi. You may like Coca-Cola over Pepsi or vice versa. They're providing the same types of goods, right? Carbonated soft drinks, but those different trademarks in connection with those goods helps them distinguish those goods from their competitor or from another party, right? Helps create that brand loyalty, also that brand identity, that brand distinction. So having that trademark distinguishes one's goods and their services from those of another party, and also provides you with legal protection for your brand. We also talked about the things that a trademark does not do, right? A trademark does not give you exclusive right to terms or phrases that you may have in your trademark, but it does provide you with some protections, federal protections, when you are getting that federal registration from the USPTO. So when you have that trademark, it only provides you with an exclusive right to use those terms, those phrases, numbers, letters, whatever you're using in connection with your goods and or services that you've indicated to us in your application. Right? So when you come to the USPTO, you are coming with a trademark that you already have or that you've already created. And our mission is to register any trademark that is eligible for registration. We know that when you come to our office, you are not buying a trademark. You're already coming to our office with a trademark that you've created, that you already have, and you're paying a fee for the application, but you're not buying a trademark from us. Not every trademark is going to be registrable. So when you file an application with the USPTO for that trademark registration, there is no guarantee that it is going to move toward the registration process or that you'll receive that registration or that federal registration. And your filing fees are not refundable. So the filing fees that you file for those applications or for that application is not going to be refundable if your application does not move forward to registration. Okay, so that fee is paying for the examination of that application and not buying or paying for you to receive registration. Okay, so you are applying when you pay those fees with your application for that trademark federal registration, but there's no guarantee because it is going to be reviewed by an examining attorney in our office to make sure it's meeting, your application is meeting all of the requirements to move forward to registration. Okay, so now that we've gotten those basics out of the way, you're probably here because maybe you already have started that process, the application process, and you're moving toward registration, or you already have trademark registrations and you want to know how to maintain that registration, what you need to do after you receive that federal registration. So that's what we're here to talk about today, or talk about a little bit more in depth today. So there are required post-registration filings after you receive that federal registration from the USPTO. This is how you're going to maintain your federal registration, because once you receive a federal registration for your trademark, you may have that in perpetuity as long as you're continuing to file the required post-registration filings and fees. And we're going to go through those, how you do that, what's the requirements to maintaining your federal registration. So first, you're going to go to uspto.gov and you're going to file your post-registration documents just like you do with your application in our trademark electronic application system. That's our TEAS system, and that's electronically. You'll be filing all post-registration documents electronically. There are some limited exceptions to where you would be able to file in other ways, but generally and most commonly, you will be filing that electronically. You don't have to necessarily worry about filing in any other way other than electronically. Those limited exceptions that you can sometimes think about are those that may have occurred prior to during the pandemic. There are citizens of exempt treaty companies that can sometimes countries that can sometimes file not electronically, or you have specimens, that evidence that you need to give us regarding your mark that you need to file that are non-traditional, and it could be a scent mark, could be a flavor mark, something of that nature. So you do have to actually submit something that is tangible, not just electronic. Or you can petition because you have some type of extraordinary circumstance that you need to do so to file electronically. I'm mentioning this one here because sometimes you're on island, sometimes there are some weather issues, etc., that make it not feasible for you to file electronically, and that could possibly be an extraordinary situation where you'd be able to file in another manner other than electronically. But like I said, commonly you'll be filing NRT system at USPTO.gov. So your required post-registration filings are a Section 8 declaration. So you'll be filing over a period of time to maintain your registration after you receive that federal registration, and the required filing for Section 8 is between the first 5th and 6th years. That's called a Section 8 declaration. This is going to be a sworn statement that you're letting us know that you're still currently using that mark in your registration in commerce with the goods and/or services that you have in your registration. And if you're not using that mark in connection with specific goods or services in your registration, that you are telling us that there's a particular reason, a special circumstances that you're not using that mark in connection with those goods and services, that there is non-use, and you have some facts or special circumstances to why that may be so, and you would be filing that in that Section 8 declaration. You're also going to submit specimens. You're going to provide us with owner information as well as information regarding your identification of goods and services. We're going to discuss those each step in just a moment. Also, the other type of required post-filing registration filing document is going to be called a combined Section 8 declaration and then a renewal document under Section 9. Those are filed together. Section 9 does not have a separate filing. These you are going to file between the 9th and 10th years, and then every 10 years after that. So it's going to be called that Section 8 declaration with that renewal Section 9 application for renewal. Let's go through and talk about that Section 8 declaration, the first type of post-registration filing that you're going to file after you receive your registration. All right, so that Section 8 declaration, this is what you file between the first 5th and 6th years after the date of your registration. So within the first 5 years of you using this particular mark in commerce with these goods and/or services in that registration that you have. So you file between that time period. You may be thinking to yourself, hey, what if I want to go ahead and file early? I don't want to wait between the 5th and 6th years, where you're not able to do that. You have to wait until the 5th and 6th years in order to file that Section 8 declaration. It will not be accepted anytime prior to that. That filing fee is going to be $225, per class. So if you have one class in your registration, $250. If you have two and so forth, you'll be paying those additional fees. So as we talk about your goods and services or those classes that you have in your registration, if there's some non-use, that's something that you want to think about as far as the fees that you're going to be paying in connection with that Section 8 declaration. Now, you do have an option for a 6-month grace period to file this declaration with a fee of $100. So you'll be paying for that grace period and also that declaration fee of $225. So if you need more time to provide that declaration, you can ask for that 6-month grace period with a fee of $100. And these are the current fees as they are current now. So the requirements for your Section 8 declaration, what do you need in order to file that declaration, or what information you're going to have to provide to the USPTO to let us know about your registration and how you're currently using it. So first, you're going to want to correctly identify the current owner of that registration or that registration, that trademark registration. So this is something to note if there has been a change in your business entity. Have there been a change in ownership? Maybe you're an individual, now it's joint owners, et cetera. Something that you need to tell the USPTO about to change as far as your ownership, because we're going to be looking at your registration or checking that against your registration to make sure that the current owner is the correct owner. So this would be a reason why if you file that declaration, you may be refused upon review if that owner information is not up to date, if it's not correct, if you fail to file with the current owner, or there are errors in how you correctly identify the current owner. So if there has been a change in your business in that first 5 years, you would be needing to record an assignment to change that ownership information with the USPTO prior to filing your Section 8 declaration, because we want to make sure that the registration is going to also align with what you have in your Section 8 declaration as far as ownership. So you'll be making sure that you're correctly specifying your current owner. You're also going to correctly specify your goods and or services. So in your registration, you have the goods and services that you applied with, and you need to include the goods and services that are still in use. So you're going to tell us, hey, I'm still using my trademark in connection with these goods and services that are in the registration. And if you have goods and services that are in your registration that you're not currently using your trademark in connection with, you need to also include those goods and services and the reasons why, that excusable non-use. So it can't be that I'm not currently using my trademark with those goods and services because I'm not selling those particular goods and services. That's not going to be a good enough reason, because when you receive that trademark registration, you're not receiving that just to hold your trademark. You have to be using it in commerce with your goods and or services. Our trademark usage rights for the U.S. and U.S. territories are based upon usage. So you have to be using that mark in commerce with those goods and or services. And if you are not, you have to have an excusable non-use reason or special circumstances of why you're not doing so. If you have goods or services that you're not using for whatever reason and don't have that particular special circumstances, you would need to be deleting those goods and services that are no longer in use with that particular trademark. You need to let us know that information. So we'll be talking about that third point, deleting goods and services no longer in use, a little further in the presentation when we're talking about our post-registration audit program. And this is a program where we may contact you randomly to say, we need this additional information about the goods and services that you have in your registration to ensure that you're still using this trademark in connection with these goods and the services. And if you're not and don't have an excusable non-use reason, you will be paid or charged or paying a fee to remove those particular goods and or services. So we'll talk about that program a little later on, but that's just something I wanted to note here so that you can be thinking about if you have goods and services that you're not using, that you want to delete them so you can avoid paying those additional fees to have them removed. Okay. And then you're also going to provide us with an acceptable specimen. Specimens are the evidence that you're providing us that you're using that trademark in connection with your goods and or services that you have in your registration. So here with your Section 8 declaration, you want to make sure you're telling us who the current owner is, who correctly specifying your goods and or services, and as well as submitting your acceptable specimens in connection with that trademark. So let's talk about our specimens for a little bit, and what you're going to be submitting as far as that evidence that you're using that trademark in connection with the goods and or services. Now for goods, you want to think about showing actual use either on your actual products, maybe the packaging for the products, the containers for those products, maybe those labels attached to those containers for your products, or unaffixed labels that have certain information on labels that is common information that may be on a label, whether that is some type of information such as like the weight, ingredients, something of that nature on those unaffixed labels. For services, you want to show a direct association between the services as well as between the trademark. We'll discuss those shortly. So an acceptable specimen. We want to show that the trademark is actually used in commerce on the goods and services that are in the registration. Your registration, when you're filing that Section 8 declaration, is what we are using to make the analysis that you're currently still using this mark in commerce. So whatever you have in the registration is what the post-examination attorney is going to be reviewing to make sure that those things align. That's why you want to make sure you have that correct owner information. You want to specify the correct goods and services, and make sure so that when you're submitting your specimen, that it aligns with the goods and services that you have in your registration. And you also want to show essentially the same trademark in the registration on your specimens as well. You want to make sure that those are essentially the same. Again, we're looking at that registration certificate from the 6 years ago to make sure that they're aligning with what you are submitting in your Section 8 declaration. So let's talk about what an acceptable specimen is, what they are, what they the requirements they must meet in order to be acceptable. So acceptable physical specimens, again, you're not actually physically sending in your product or your goods. Back in the day, a long time ago, you would have to send in specimens to our attorneys to examine, but now you are able to send photographs of those specimens for us to see. So your trademark has to either appear on the goods themselves, talked about that. They can appear on containers or packaging for the goods. They can appear on labels or tags that are fixed to your goods. And also you can submit labels and tags that are unaffixed on the goods, but they have to have some type of informational matter that is typically found on labels and tags. So what type of matter is typically found on the label or tag, right? Think about those UPC barcodes or a list of contents or ingredients. Maybe you put the net weight or value, a volume on those particular tags. Maybe they are labels, maybe the model or part number, anything or any informational matter that is typically on a label. You can submit that label unaffixed to those goods if you have those, if you have that information in relation to those labels. Okay, so either on the goods themselves, either on the containers or packaging, either on those labels or tags that are affixed to the goods, or those unaffixed labels and hang tags. Let's look at an example here, a real example. So here, the trademark is Tulip, and it is a registered trademark for iron-on transfers and stencils, sponge paint applicators, felt marking pens, paint applicators, paint brushes, and sponge paint brushes. I'll go over really quickly after this example why I mentioned everything that's in the registration. So a registration for all those goods, and we're seeing an acceptable specimen here that is showing the felt marking pens, fabric markers. So we see Tulip here in the upper left-hand corner, that's the trademark on the packaging or on the particular good. So this is an acceptable specimen example. I mention everything that is in the registration because we know that you only have to submit a specimen for one of the goods per class, one of the goods and or services per class. So you could have one class of goods that have several types of goods in that one class, and you just need to submit one specimen per class. You don't have to submit a specimen for each of those goods that are in the class. You may, if you just want to submit additional specimens, but you're not required to. You just have to submit one. So if you have 5 classes that have multiple items in goods and or services in them, you just need to submit one specimen per class. So essentially 5 specimens, okay? Let's look at another acceptable type of specimen for website specimens. You can submit a website specimen or photographs of your actual goods and or products, but if you want to send us a website specimen, it is going to have to include the URL and the access date. You can include that in a screenshot, or you can, and then you're going to include in your specimen description field what is on that screenshot. So when you're submitting that specimen, you're going to see an area where you can describe what is on this website, and you're going to describe what is on there, where the trademark is, where that URL is, and where that access date is, and you're going to fill that in for your specimen description. You would provide this in a response. If you received an office action, you will be able to provide this as well. So let's look at what is acceptable for a required website information specimen. So here is another real world example. We have a registration for the mark Base Camp, Wine and Spirits, BC, Frisco, Colorado. So that's the mark. And then the services are retail store services featuring alcoholic and non-alcoholic beverages, foods, snack items for consumption on or off the premises as allowed by law, glassware, bar supplies, cigars, and gift baskets. So retail store services, essentially for the mark Base Camp Wine and Spirits, BC, Frisco, Colorado. So let's look at our specimen, our website specimen. Let's make sure that we have that URL. So in the top left-hand corner, you're seeing circled in red in the browser area, that screenshot is showing that website. So we know what the website is. And then on the bottom right-hand corner, you're going to see a red circle that is showing us the URL, the access date, the time and access date there. And then where's our trademark on this particular screenshot? Right there in the center on that seal-like design, that red seal-like design, we see Base Camp Wine and Spirits, BC, Frisco, Colorado. That's where our trademark is. And then in connection or the direct association with the services are one we can see on the front, on the home page. It shows that they sell beer. I see bombers, wine, spirits, cigars, and bar essentials. So we know that is in their services. And then they even on that front page, we can see an actual storefront showing those retail store services. So with a website, you have to show a direct services, you have to show a direct association between the mark and the services. And we can see that here with this screenshot, this acceptable specimen. All right. So let's talk about essentially what we have to have on that specimen as far as the trademark to make sure that they are essentially the same trademark. It must create the same commercial impression. So what we're seeing in the registration, remember, we're doing our analysis based upon the registration, also has to be similar to the same commercial impression that we're seeing on the specimen that you're submitting in your declaration. You cannot have a material alteration of your trademark from what is shown in the registration. So a material alteration means that you have a completely or something changed about it that makes it a different version of the trademark than as it appears in the registration. So you cannot have a material alteration, and this would result in a refusal of your Section 8 declaration. So you want to make sure that they are essentially the same, have the same commercial impression. Now, if you have mere changes like in the background or styling, or there's some modernization, that does not necessarily ordinarily mean that you're going to have a material alteration. But remember, we are always going to be looking at that registration and using our analysis based upon those facts. What you have in the registration, is it a material alteration from that? So even if other, you might look at other registrations and say, well, they had some different stylization that changed in that 5-year or that 10-year period or something of that nature. We're only going to look on the facts based in your case, in your particular registration. So keep that in mind. Let's do a quick knowledge check of some types of specimens and how they look compared to the registrations to see whether or not they would be acceptable. So just like I did last time, if you are here, you want to participate, get a little bit of interactive, see what you've learned so far, you can drop in the chat a yes or no whether or not you think these trademarks are essentially the same as the registrations in these Section 8 declarations. These are going to be real world examples. And I'm just going to open up my chat here so I can see if you're interacting with me. All right. So our first knowledge check. Are these trademarks essentially the same? So our registered trademark here is CD Corey Delta, that underscore constructors, CD Corey Delta. And then they filed in their declaration the trademark on the specimen. Their services are industrial construction services for others, industrial construction services for others. Are these trademarks essentially the same when you're looking at the trademark on the specimen? Oh, I'm seeing answers come in. Thank you for your participation. And I'm getting yeses. Correct. Yes. The additional wording that is on the specimen says an employee-owned company. That is merely informational and it lacks trademark significance. It doesn't change the commercial impression of CD Corey Delta underline constructors. It is just some information. It has no trademark significance. So here, this would be likely an acceptable specimen for that Section 8 declaration. Great. So let's go to our next knowledge check. Are these trademarks essentially the same? The registered trademark is RoboMelt for chemical preparations for melting snow and ice. And then the trademark on the specimen is showing RoboMelt in some stylized font and colors. We see some additional wording like ice melter. Are these trademarks essentially the same? See, I'm getting some answers here. Is RoboMelt as shown on the specimen, are these essentially the same? And the answer here is going to be yes. Okay, so RoboMelt and the registered trademark was filed in a standard character format, meaning it was filed without any type of font size, color, or stylization, which means out in the marketplace, they can stylize it in any way that they so choose. So with that standard character format, they can style it in any way they so choose on their or out in the marketplace. So in the specimen, we do see some stylization, right? We see different font size, we see some color, but they're allowed to do that because they filed that standard character format. And this stylization or the additional wording even here on the specimen doesn't create, doesn't add anything, doesn't create any type of trademark significance, doesn't change the commercial impression. RoboMelt still stands alone, creates a separable impression from that additional wording that appears to be just kind of descriptive or informational. Let's do one more knowledge check. Are these trademarks essentially the same? So we have NACO or NACO for association services, namely promoting the interests of county governments. We see the registered trademark of NACO, National Association of Counties, Counties for America, with those squiggly lines, looks kind of like a flag. And then the trademark on the specimen is NACO, National Association of Counties. We still have those design elements. And then the Voice of America's Counties underneath. So are these trademarks essentially the same? Let me know in the chat. So we're looking at the marks, we're looking at the design elements, we're looking at the wording to see if they're essentially the same. And the answer here is going to be no. And let's take a look at that. So we see in our registered trademark, they have specific wording, National Association of Counties, Counties Care for America. And in the specimen, so remember I said it doesn't matter if the background color is different because the actual trademark might be on a bag or on a pamphlet that is gray. So that gray box doesn't really change anything as far as the trademark. But let's look at the wording, the Voice of America's Counties. Is this a different slogan than what was actually in their registration? Yes. So it's changing something about the commercial impression of that registration. Counties Care for America is different, totally different than the Voice of America's Counties, right? Could have a different meaning and connotation. So therefore is changing the commercial impression than what is shown in the registration. So here it would most likely result in a refusal here when they're looking at that specimen, right? So we talked about that Section 8 filing declaration that you file within the 5th and 6th years. You can't file it prior to that time. You'll file it, you'll pay that fee of $225 per class. You're going to tell us who the current owner is, specify those goods and or services, or provide us with facts for an acceptable, excusable non-use of the mark in connection with certain goods and services, or you're removing the goods and services you're not using the mark with. And then you're also providing us with acceptable specimens of your trademarking use with the goods and services in that registration. Let's talk about that combined Section 8 and Section 9 renewal filing. So these are required post-registration filings. So the combined Section 8 declaration, that is required, we know that. And then between the 9th and 10th years, and then every 10 years after that, you'll be filing the Section 9 in conjunction with that Section 8 declaration for renewal. So this is due again 9 and 10th years after the date of registration, and then every 10 years after that. So you see with filing these post-registration documents, you'll be filing every 10 years. So you can have that trademark in perpetuity as long as you're filing those post-registration documents every 10 years after that first Section 8 declaration. Okay, so even past your own life, or as long as your business or your business entity, as long as they keep filing that post-registration documentation, then you can have that trademark, be the owner of that trademark registration. The filing fee here is going to be $525 per class. So the fees are increased $525 per class. And then you have an option of that 6-month grace period to file. If you're not quite there yet or not ready to file that combined Section 8 declaration and Section 9 application for renewal, you'll be paying $200 fee for the grace period in conjunction with your $525 per class when you're filing that combined post-registration document. There is no separate Section 9 application for renewal. You file it in conjunction with a combined section, with a Section 8 declaration. So it's not going to be a separate document that's just going to be Section 9 renewal that you're filing every 10 years. It's always going to be filed in connection with that Section 8 declaration. And these are the current fees. So 9th and 10th years after registration, then every 10 years after it. What are the requirements that you need for that combined Section 8 in that Section 9? So we know some of the requirements for Section 8 are to correctly identify the current owner. We want to correctly specify our goods and services. So we're including the goods and services that are still in use. We're including goods and services with excusable non-use and deleting goods and services that are no longer in use. Remember, we want to do that prior to review if we have to, so that we don't have to pay fees in order to remove those goods and or services. And then we're going to delete goods and services no longer in use and submit our acceptable specimens. So the Section 9 request is going to be automatically part of the form once you are in that 9th and 10th years, and then every 10 years after that. Again, no separate, just alone Section 9 form. You're going to receive a reminder from the USPTO prior to filing these documents. So you want to make sure that you have an updated email address. Remember, you're only receiving communications from us electronically through the T system. So you always want to make sure you have the current owner information as well as an updated email address for us to contact you or to send that reminder. You are responsible for keeping up with that time period, but we do send one reminder letting you know, hey, your renewal or your declaration is coming up, your combined renewal is coming up. You need to be on the lookout to file those particular documents. All right, let's do a quick knowledge check. Again, you can drop your answers in the chat. Let me see if you're still there with me. Can you file a Section 8 or a combined Section 8 and 9 document before it is due? Can you file it before the 5th and 6th years or file it before the 9th and 10th years? Are you able to do that? And I'm seeing the answers coming in. Thank you. And the answer here is no. You can only file the required documents in the available 1-year window. So between the 5th and 6th years for that Section 8, between the 9th and 10th years for the combined Section 8 and Section 9 renewal document, and then every 10 years after that. So you can't do it before. We will send you a reminder right before, but again, you are responsible for keeping up and maintaining those dates and documents. Thank you for your participation. So those are required documents, our Section 8 declaration, as well as our combined Section 8 declaration and application for renewal under Section 9. Let's talk about some optional post-registration filings, okay? Not required. Optional filings are Section 15, Declaration of Incontestability, and we'll discuss what each of these are momentarily. And then our Section 7, Requests for Amendment or Correction of a Registration. So these are 2 optional filings. Let's discuss what those are. So Section 15, Declaration of Incontestability. This protects your registration from some challenges. So when you're filing your required documents, you may say, hey, I don't want to deal with a challenge of possible descriptiveness of my mark, or geographic descriptiveness, or that my mark is primarily merely a surname, okay? So this helps protect your registration from those challenges. It's not going to protect your registration from challenges regarding genericness. Now, we talked about genericness as far as the strength of your trademark. Generic means that it is what it is, that you're just using a term or a phrase or slogan or terms and words that just identify what the actual goods and services are. They don't even describe them. They just tell us what it is. So the example we like to use is milk for dairy-based beverage, right? That is what milk is. So that's generic. So if you file a Section 15 declaration of incontestability, that is going to you're not going to be able to get around genericness. We're going to say this is not going to be allowable for your registration. You can't get around functionality, that your mark merely is indicating the function of your particular goods and/or services, not for abandon. You're not going to be able to beat the challenge of abandonment, that you have a trademark that you're not using, that you just abandoned, and you're not using it at all in connection with your goods and/or services, and you have no reason why you're doing that. You just abandon that particular trademark. You can't use this particular declaration for fraud against the USPTO or false suggestion of connection with another mark, with another person, with another owner of another trademark. Okay, so this will protect registration from, if your mark is descriptive, geographic descriptiveness, primarily merely a surname. This is something that you could possibly file in connection with that. Incontestability means there's not going to be any dispute against your particular registration for these particular reasons. The filing fee for this, you can file in conjunction with your Section 8s or with your combined, are the $200 per class. Requirements here are that your mark has to have been registered on the principal register. The principal register gives you certain benefits regarding your particular mark. Now, if your mark was filed on what is our supplemental register, you would not be able to file a Section 15 declaration. What is the supplemental register? It is a secondary register for marks that are not inherently distinctive. So when you're choosing a mark or have the strength of your mark as far as your registration, we know weak marks are those generic marks. It is what it is. It's explaining what the actual goods and services are. So it doesn't really provide any trademark significance. Or a descriptive mark, those are weak marks. Descriptive marks merely describe something about the goods and/or services. Now, sometimes you can have a descriptive mark registered on the supplemental register, meaning that it's not inherently descriptive, but the office is saying that in a particular amount of time, it may become inherently distinctive for you to move over to the principal register. And you'll have to provide us with evidence for acquired distinctiveness showing us that. But if your registration is on the supplemental register, you cannot file a Section 15 because it's basically saying that that mark is descriptive, it's geographically descriptive, it's primarily merely a surname. You're receiving all the same benefits of the principal register, but it's indicating that this mark is not inherently distinctive. You'd have to show us inherently distinctiveness prior to filing this declaration of incontestability, because your mark would have to be moved over to the principal register in order to file this declaration of incontestability. You have to be using your mark in continuous use for at least 5 consecutive years after registration in order to file that Section 15, and there can be no adverse final decisions or pending proceedings against your trademark. So that can be in relation to several types of factors, that you don't have anything in court regarding the ownership or the right to register or keeping the registration, no type of federal, any type of cases or adverse proceedings regarding your registration. This is where you would be able to file that Section 8 or the requirements you would need, a Section 15 or the requirements you would need for that. Again, $200 per class in order to file this particular document. You can file it, like I said, in connection or in conjunction with your Section 8, but you would be paying all those fees together. So if you have one class, you'd be paying $200 for that Section 15 declaration of incontestability, and then your $225 for your Section 8 declaration. So $425 in total. If you have more classes, that's going to increase. The other optional post-registration filing is our Section 7 request to amend registration filing. This allows you to amend your trademark in your registration to agree with your trademark that is currently in use. So we looked at those like acceptable specimens. If you're not making a material alteration or you need to change something in your trademark that is currently what you have in use in the marketplace, you're able to do that with a Section 7 request to amend, keeping in mind that it cannot be a material alteration of your registration or the trademark as it appears in your registration. The filing fee there is $100 per filing, not per class, per filing, because here you're just changing wanting to change something about the the trademark in the registration, not specific to the classes, the goods and services in the registration. So here you would just be letting us know that you want to change something about that mark. The requirements here, like I mentioned, are that there can be no material alteration of the registered mark. You're still going to be providing one specimen per class of what you're currently using out in the marketplace in connection with your goods and services, So again, material alteration, just want to note that it has to still be essentially the same mark or similar to the same mark, creating the same commercial impression. And I just kind of quickly went over, we're going to do some knowledge checks so you can see if that's something that you're considering. Maybe you've had your mark for a significant period of time, and there have been some changes that you're using in the marketplace, and you want to go ahead and change that on your trademark registration. So let's do some quick knowledge checks. So here, is this amendment going to be acceptable under that Section 7? If you file that Section 7, the registered trademark is Stadler Rail for railway vehicles with a disclaimed wording of rail. And in the marketplace, they are using Stadler for railway vehicles. Would this be acceptable under Section 7 request to amend? Would the USPTO allow this? I'm looking at your answers coming in. Stadler Rail for railway vehicles, Stadler for railway vehicles. Seeing the answers coming in, thank you. All right. Okay, so I'm getting a lot of no's. So let's look at that again. So rail in the registered trademark has been disclaimed, meaning the company or the owner of that particular trademark has said, I know I don't have exclusive right to use the word rail in connection with railway vehicles. I know other people would have to use the word rail. So it's descriptive. It doesn't have strong holding. It doesn't remove it from that trademark, but it's not really, it's a descriptive wording. So if they remove it, if they're using it out in the marketplace and they remove it, since that word rail is generic for their goods, railway vehicles, then this would be an acceptable change, okay? So it doesn't change the commercial impression of the mark. It's something that is just taking away that generic, that descriptive wording for railway vehicles. So here, the amendment would be acceptable. Let's look at another one. So would the amendment be acceptable here? The registered trademark is Northern Anchor Account for banking and financial services. And then the proposed trademark is Northern Anchor for banking and financial services. They have a previously disclaimed the wording account in connection with banking and financial services. So would this amendment be acceptable here? Seeing some of the answers come in. Northern Anchor Account versus Northern Anchor with account removed. And I'm seeing the answers coming in. Thank you for your participation. And the answer here is yes, this would be an acceptable amendment, right? We just talked about a similar case with Stadler Rail and Stadler for railway vehicles. Account is generic in reference to these banking and financial services. So the removal of that doesn't change the commercial impression of Northern Anchor. It's not as strong as a word. They had it in their original registration, but they just want to remove that and just have Northern Anchor. So this would be an acceptable amendment. Let's do one more. Change it up a little bit. Is this amendment acceptable? You have a registered trademark for base backpackers with an X over top for hostel, hotel, and motel accommodations. And then the proposed trademark still has this X. It has a little bit of change here for base with removing backpackers for hostel, hotel, motel accommodations. They had previously disclaimed the wording backpackers in the original. So let's see if this amendment would be acceptable. Looking at all of the elements of the mark, would this be an allowable amendment? I'm seeing the answers coming in, and I'm getting no's, right? No's here. So the answer here is no. The deletion of backpackers creates a different visual impression from that of the original registered mark, right? So we see some differences in the actual design element, and then base backpackers and just base changes the commercial impression of the type of hostel, right? Hotel, motel accommodation. So it's changing kind of the meaning and connotation, that commercial impression. So the disclaimer wording doesn't really matter here. The wording is descriptive. It's not generic for the services, but it is functioning in some way to kind of let us know a little bit about this particular mark. And then the deletion of backpackers therefore creates a different commercial impression. All right, thank you for your participation. So let's talk about our registration examination, So we know we have those required filings, that Section 8 declaration, and then a combined Section 8 declaration with a Section 9 application for renewal, and what it looks like when you file those in the examination process. So if the filing is acceptable, the USPTO is going to notify the registrant, sorry. These are going to be reviewed by post-registration division examiners. And when you file like a Section 7 request, they're going to look at that mark, see if the filing is acceptable. If that amendment is acceptable to that registration, they're going to publish the mark in our official gazette 2 to 3 months after publication, because we have to put the public on notice that there has been a change to the mark under that Section 7 amendment. They're going to update your registration certificate and issue that to you electronically. For the Section 8 declaration, they're going to issue that notice of acceptance saying, hey, we've accepted your Section 8 declaration, showing that you're still using the trademark in connection with the goods and services in the registration. So that has been accepted. With that combined declaration and that Section 9 application for renewal, we're going to issue that acceptance and grant that renewal to you. And with a Section 15 declaration, we're going to say, hey, we acknowledge that your mark has now been is incontestable. So we're acknowledging that, and it's going to be that filing is going to be accepted. Now, if your filing is unacceptable after review by the examiners, the USPTO is going to issue an office action. They're going to require a response to that office action if you want to move forward with that declaration or with that filing that you've made as far as a renewal. So with required filings, again, that Section 8, that combined Section 8 and 9, your optional filing Section 15 and Section 7. I'm mentioning this to say that you do have the right and the option to provide a response when you receive an office action. So an office action is not an end-all be-all. You're able to provide a response to that office action based upon what is in the office action. The required filings, once you receive that office action, you have 6 months from the date of the office action to provide us with a response, or by the last day of the statutory filing period of that particular filing. So say, for example, you have filed that Section 8 declaration between the 5th and 6th years, and you receive an office action. In office action, you can file that response within that date, but if you still have time left in when you were supposed to file between that 5th and 6th years and it's longer, then you have that particular time period to file your response. So you have to keep up with what that timing is or what that timing looks at based upon when you actually made your filing. Now you have those optional filings you have to file within 6 months from the date of the office action. Remember, they are optional. So there is no requirement as far as the statutory period for those filings. And since they're optional, you only have the 6 months to provide us with a response if you receive an office action. So again, those are our Section 7 requesting to amend your trademark registration, as well as the Section 15, that declaration of incontestability. So once you receive an office action, you may be required to pay a deletion fee. So remember, I stated that in your Section 8 declaration, you have to let us know of your goods and or services. If there are some that you have an excusable non-use for, or you may want to delete prior to receiving an office action where you have to pay a fee if there's something that needs to be deleted. So if they're reviewing that declaration and they see, hey, you're not using this trademark in connection with these particular goods, or there's something that needs to be removed, then you will pay a deletion fee. That's going to be $250 per class. So that's why you want to think about that upfront in your declaration prior to doing so. The fee is required if you delete goods and services or classes from your registration after you file that Section 8 declaration and before the USPTO accepts it. That filing fee is $250 per class. Deletion fee, there's no fee required. So this is where we want to be thinking about how we can not pay those fees if you delete the goods and services in your Section 8 declaration. Okay, so if you already know, hey, we're not using our trademark anymore in connection with these particular goods and services with their registration, I want to go ahead and remove them when I file my Section 8 declaration. If you file a Section 7 request and delete those goods and services before you file that Section 8 declaration. So remember, with your optional filings, you can file them in connection with your Section 8. So anytime you're removing prior to filing that declaration, you don't have to worry about paying those deletion fees. So it's important that you want to make sure what you have in your declaration is accurate, because we are basing it upon your current registration or doing the analysis based upon your current registration. In our post-registration audit program, so this was launched in 2017, and this allows the USPTO to cancel or amend the identification of goods and services and registrations for trademarks that are not currently in use. So say you have that, you don't have an excusable non-use for those goods and services, you have not deleted them, your application or your declaration may be registration may be chosen randomly for additional information where we say, hey, we want you to submit additional specimens in connection with specific goods and or services that are in your registration to see if you're still currently using your trademark in connection with those goods and or services. Excuse me. There it is. So this is going to require submission of additional proof of use. This is random through the audit program, and this helps ensure for the public, for innovation, that you're not just holding a trademark in connection with goods and services that you're not currently using or don't have an excusable non-use for. All right, so we know about those required post-registration documents of Section 8, the combined Section 8 and Section 9 application for refusal, are optional filings under Section 15 and Section 7. Section 15 for that declaration of incontestability. Section 7 is if you want to amend something, amend your trademark in your registration without any type of material alteration. All right, so we're all good to go. Let's talk about some of the resources that we have. So first, we always want to point out to beware of scams, beware of non-attorney filing firms, and beware of misleading notices and offers. So anytime you're filing any documentation with the USPTO, it is public record. It is going to show on our website. This is for innovation so the public can see if there are any types of oppositions or anything like that. So because of that, because that information is made public, or those documents that you're providing are made public, that you may sometimes be contacted legitimately by attorneys, but also you may be contacted fraudulently by those who are attempting to scam you, usually out of money, something out of your pocket. One way you know is that once you receive your registration, it's not guaranteed as far as your documentation that you're doing, as far as your post-registration documents, right? Because someone is going to be reviewing those documents. So if someone is telling you they can guarantee something, that if you just pay them a certain amount of money, they can guarantee this, then you know that's more than likely a scam. Okay, any communications coming from the USPTO are going to end in @uspto.gov as far as email addresses. Beware of filing firms. If you're getting someone to file, a filing firm to file these documents for you or on your behalf, you might want to see if they have an attorney on staff that can assist you if you receive any type of office actions, because only an attorney can represent you in front of the USPTO, only yourself as the owner or an attorney. So if those filing firms do not have an attorney and you receive an office action, they would not be able to assist you. You would have to do that on your own or hire an attorney to assist you. So just beware of those misleading notices and offers. You can go to our website to see some examples of what we've seen out in the marketplace that people have received, that applicants and registrants have received on these particular websites, at these particular parts of our website. Always, as our hub, you go to USPTO.gov. We have trademark videos from attorneys like myself in our office, our Trademark Customer Outreach office, about every step and aspect of the federal registration process, including post-registration filings as well. You can scan this QR code or go to this link for our Trademark Basics Registration Toolkit. If you're just starting this process, going through the process, have any questions about the process or where you are in that process, this will provide you with additional more concise and information about this. It's also going to give you information about our Trademark Basics Bootcamp. It's an 8-week series that we provide here at the USPTO for free, when an attorney like myself in our office is providing live webinars about every step of the registration process. You can look at our agenda, you can attend all 8 sessions, or you can say, hey, I am in a particular place in the process or the journey, and I just need to attend this 1 session or 2 of these sessions. You're able to ask us questions live. We can't provide legal advice, but ask us questions live about the subject matter of that particular presentation. The last bootcamp just ended this past Tuesday, and the next one is going to start on October 1st. So you can go to that registration basics toolkit to look that up as well and to sign up if you are interested. Again, all free resources. Our IP identifier is going to tell you information, provide you information if you're like, I have several types of intellectual property, I believe, but I don't know which type, and I don't know where to go to get them protected. This is going to ask you a series of 6 questions about your intellectual property, as well as at the end of that questionnaire, provide you with the resources of where you need to go to get that protection. This is also a link to our free services. All resources from the USPTO are free. So this is free services and resources, as well as our USPTO virtual assistant that is currently in beta, but it covers about 25 of the most commonly asked trademark questions. You can go there to interact with the virtual assistant. Our Trademark Assistance Center is our MAID support center for all trademark customers. The phone number, they are available Monday through Friday, 8:30 a.m. to 8 p.m. Eastern time to answer your questions regarding trademarks in the federal registration process. They cannot provide legal advice, but can give you information. A great resource if you're receiving any of those fraudulent communications and you're like, I don't know if this is from the examiner or at the USPTO, I'm not really sure, it looks legitimate. You can contact our Trademark Assistance Center, let them know what you received, and they can let you know, yes, that's from your trademark examining attorney, or no, it is not. It is not from the USPTO. You can also email them at that email address, and email responses are usually within 24 to 48 hours. The USPTO does not provide legal advice. We cannot enforce your legal rights. So once you receive that registration, we can't enforce any rights regarding trademark infringement, et cetera, anything of that nature. You are still required to file your post-registration documentation, but that is, we cannot assist with any type of enforcement. We cannot recommend specific private attorneys. We do have our law school certification program, which you can find if you search on USPTO.gov in our search bar. If you're like, I'm going through these sessions, I don't necessarily want to do this process by myself. I would like to work with an attorney. If you are hiring an attorney, hire an experienced, a private experienced trademark attorney. And with our law school certification program, you would be working with the law students at various law schools around the country that accept clients and they're working under their professor who is a licensed attorney. They can assist with either free or reduced fee legal services. Remember, your best resource is always an experienced trademark attorney. You're not required to use an attorney. We recommend it, but you're not required to. We do provide you with resources to move forward on your own if you feel like you would like to do so. Most trademark filing companies can only provide those limited services. They can only file something on your behalf. They cannot represent you in front of the USPTO. So if you're working with a filing company, you can ask them if they have an attorney on staff who will work on your behalf. Just make sure you're asking that prior to. In the event that you get an office action, you would have to hire an attorney after the fact, or you would have to be responding on your behalf. on your own behalf. All right, with that, we're to our questions portion of today's presentation. I am going to stop sharing. I'm going to check out the chat to see if we have any questions. And if you currently have some questions, please feel free to drop them in the chat. I'm going to stop sharing here. I'll just leave that up.
Hey, Christina, it's me, Gautam.
Hi.
Do have one question, I
Okay.
think, and let me pull up the chat quickly. The question is, what happens if you don't pay the deletion fees if required?
So if you don't pay those deletion fees, if you receive an office action and they're concerned or they have a question regarding those deletion fees, you run a risk of your trademark registration being canceled. So you would essentially lose your trademark registration, because again, a trademark registration is not just to hold a registration for you. You have to be using it in connection with the goods and services that you have in that registration. This protects the public, right, and innovation. Because if you're just holding it and you're not using it in connection with those goods and services, if someone were to attempt to apply, excuse me, for a similar mark, confusingly similar mark, where we talked about likelihood of confusion for goods and or services that you're not currently using, that would prevent them from moving forward, even though you're not using your mark in connection with those goods and services. We want to prevent that. We want to foster innovation and invention. So we want to prevent that. So you run the risk of your trademark registration being canceled if you don't pay those deletion fees. You're either going to need to provide us with special circumstances or reason that you're not using your mark in connection with those goods and or services. Any other questions? That means everybody got everything they needed. They know it back and forth. All right. Thank you again for your participation during the knowledge checks and for your questions. All right.
All right, so I guess that's it in terms of questions. So
Yes.
I'll go ahead and
Sure.
interject here by closing out on behalf of the VI-SBDC. So the VI-SBDC has so much more in store for you as VI small businesses. You can visit our website at www.visbdc.org. Download the VI-SBDC app on your mobile device from the appropriate app store. Like and follow us on Facebook, Instagram, Twitter, Google Business, and subscribe to the VI-SBDC YouTube channel for new uploads of our on-demand webinars. Just a few webinars that we have coming up. Tomorrow on August 29th, we have safety and health practices for USVI businesses. We have a USPTO office returning on September 4th. And that session is entitled Learn About US Design Patents. And on September 6th, we have the VI Energy office, and they're going to be covering energy efficiency tips for USVI brick and mortar businesses. So I'm just going to pay attention to the chat to see if we have any more questions. I don't see any more questions at this time. So on behalf of the entire VI-SBDC network, we want to thank our USPTO Outreach Office for collaborating with us on this initiative. And we would like to thank everyone in attendance and wish them a productive rest of the day. Bye, everyone.